Praise Him. I want to thank you for tuning in and speaking low. Hopefully you can hear me, but the location I'm in right now, motel, and I'm thankful to be here. So I don't want to speak loud or anything with that to cause a disturbance or anything. Yesterday you saw me post a video showing my eviction and these closed. But I don't know if I know I had 5 minutes to get what I needed to get, and believe it or not, the most important stuff was and I pray you can hear me loud enough. But the most important stuff was the case information. I was just very unprepared in the stuff that I had. So let me just go back over this, and I thank God for some people who have offered me some assistance. And so I'll say this in the beginning because I do have my notes here. You can cash out me, and it's non-tax deductible is my company. It is T as in Tom, B as in boy, CS 360. So T as in Tom, B as in boy, C as in Charlie, S as in Sam, 360. That's my cash app. And it's non-tax deductible because it's my corporation, which was also technically evicted. I don't know the whole stance, and I'll get into that to let you all know what went on, and so my stance too as well. So yesterday you saw the eviction, and I'm a very private person. So what you saw was me actually just trying to protect myself, because things were going on already that I just needed self-protection. So the officers knew that I was Facebooking live, because they didn't come blazing, but they came blazing enough to, as far as me having guns, checking the room. And by the time you look into the video, you'll see me saying what I'm reaching for and why I'm reaching for it, saying where something is, making sure, even though the room was already checked and they said it was already checked, I'm still going to tell you what I'm doing and where it's at, because none of that was necessary. So May 4th, they put a notice on it, and they said it was the final eviction. So there was some communication, and I'm saying off the bat, it's still a part of racial discrimination claim. It's retaliation for my racial discrimination claim. When I speak of this, and anytime I speak of retaliation of racial discrimination, I want it to be understood that I'm not necessarily speaking about any officers or any people that may have assisted me. It may be the people that have assisted me by way of direction or a direct order of someone else. So it is not which is very different. It's very different. So, I do believe that the officers that was assisted me handled, it could have been something different easily. Yeah. I do think that they were under a direct order to do particular things, and that's it. But let me get to this. So they mentioned there was another notice that was placed on the door, probably so 7 days before the 4th. So around April something, towards the end of the month of April. I was already proactive with involved in trying to do something with the courts. So that was off of a final judgment, and I'm trying to stay on track too as well, because really, my pastor speaks a lot about his, and I don't know if he's joking or not, to be honest with you, when he says it, but I don't think he's joking, but I know definitely I deal with kind of like an ADD, ADHD thing. And so it's a real thing. And so things can be jumbled up, which is one of the things that happened here. I believe that it was used against me. But either way, the officer mentioned, so if you see me skip around, forgive me. The officer mentioned U-Haul truck. He saw a U-Haul truck. The U-Haul truck, to explain it to you, yes, I moved half of the things out because there were two entities that were at the same location. So to give you an analogy, this case that was brought up, and I've been mentioning this from the beginning, the case that was brought up, it was only brought up against me. It was not brought up against my corporation, which if you, Consulting Solutions 360 LLC, doing business, and then I have a DBA, which is Terry B's Consulting Solutions 360 LLC. And if you look that up on the sunbiz.org, Consulting Solutions 360 LLC, you'll see it's been registered. I mean, it's official. I have the document number. I have it right here. I just don't want to move it, if the laptop and everything. But it's actually even in the court dockets too as well, the court files. It's an interested party. It's a party who, it's like an individual. Corporations are like individuals itself. They have the EIN numbers. EIN numbers is like a social security number too as well. So it is what it is. That interested party was not served. That it still technically occupies that location at that address was not served. The officer made it clear he was going to hear me at one point, and then after that point, he was only there to do one particular thing, and that was to evict me, although there were two different parts of it. An attorney could better explain it, but I've dealt with it before. I haven't personally dealt with it before, but I've been around it enough to know that it creates a legal catastrophe when, if there's a if there's a conflicting party that has not been served, who needs to be served in a case, especially in an eviction case. And this is the thing that occurred. So some people may ask too also, and I apologize for just going places, but look, I just got evicted. I don't know what else to say, but I also wanted to give an update too as well to those, to let you know I'm fine as well. But this is just coming off. So, please, it is what it is. But just at the end of the day, getting back on track with this, I do think it prevented me from, there are certain entities that are preventing me from trying to go back to federal court. And the landlord, my mother, which is on the website, she's a part of that entity as well. So that's supposed to be on the federal court, included into the federal claim. So it is all retaliation against racial discrimination. And the trail, the financial trail, the paper trail, that I've talked about before, that I don't need to go into that right now. But the eviction occurred, in my opinion, was due to a dirty tactic. So there was already a final judgment. And I've said before that there was fraudulent to the court that happened, where there was a claim that my rental agreement expired and the expiration date was November something 2025. The actual expiration date, November 22nd, 2029. Okay. There was a final judgment that came. The writ didn't come off the final judgment of that, which was around April the 7th, I believe. I made a motion for a rehearing because that's one of the main things. There was fraud to the court. Everything I've read or anything experienced, seen, courts do not like something that is so fraudulent, and especially to take advantage of people, and especially landlords that would have to, because I wasn't supposed to know about the eviction. I don't think it was supposed to be last minute. I wasn't supposed to know about the eviction. You read on the website, click on eviction. I'll put the link in there. But a rehearing for final judgment. During the rehearing for final judgment, there was a quick thing that came in, a motion by the plaintiff in this case, because there's two related cases. My mother motioned for default judgment. And so it was found to be weird, but I didn't worry about it as much. And then there was a motion to strike my rehearing. They kind of came in at once. And when they come in, mind you, these motions that I'm speaking of, I'm not receiving how I'm supposed to receiving an email. I'm not receiving it in the email. It as in there's a court e-file service. So I don't receive it in the emails. So it comes directly to you timely, where you know you need to respond to it. How I receive it is because I have to keep going on to the Broward courts and keep refreshing. It's like every 5 hours or something like that. It's got me, if you only know what it feels like to wonder what's going on now, making sure everything's fine. No, nothing's there. Okay, good, nothing's there. Oof. To figure out, if someone, meaning my mother, filed something again, whether before she filed something, made claims that I had no pictures of her online. Turns out she switched her testimony. She switched her statement, but it caused come on. Anyway, I didn't get word of that until, everything is still coming in late. So anytime she filed something directly to the clerk of courts, there's a thing called a filing number. There's no filing number when it goes directly to the courts, when you're physically handing it. For some reason, there's no filing number attached to it, so it doesn't go to a different, like when the judge normally does a ruling, there's a filing number. This time, the judge did something that the default motion, it was a signature. There's no filing number to it. I didn't even get it. I had to refresh it on the court's website, which is weird. So getting back to that, when we had the rehearing, and the judge found out that I did not the judge found out that I did not, that I got the motion to strike very late in the game, motion to strike the rehearing. So because I asked for a rehearing of the final judgment, she then gave me 24 hours, well, less than 24 hours, about 23 hours or something, to have an official response to that. But she as in Judge Betsy Benson, made sure she stated that she was not entertaining, she was not entertaining anything else. It was only this hearing, the topic is only about the final judgment motion. The rehearing. So any other motions, nothing's gonna be heard at this time. So for me, that's like, okay, so we'll hear it. I'm waiting to hear it. Okay, where's the next time we're gonna, because I'm trying to figure out what this motion for default judgment is all about. So she doesn't want to hear anything right now, no arguments or any other motions. This is the only, I thought it was placing, okay, let's just put a focus on this, we'll deal with it. It's like, let's put more of a focus on it, because I did speak about a problem with, the reasonable accommodation and things with my disability, so I thought it was accommodating, okay, so he doesn't say anything more about his disability. Let's tackle this one thing at a time. So I thought the motion was going to be heard. So it didn't give me a chance to respond to the motion. And a motion for a default judgment, for those who don't know, is basically someone saying that they sent something to you, you failed to respond to it. And the motion for default judgment came in April 17th, 2026. My response to it, my 42, I think it was 42 or 43 page response to the eviction, was just 2 days after I received the summons. Now, in all being accountable to everything, page 8 was missing. Page 8 was missing, but it was argued on February the 24th. So mind you, a motion for final judgment, meaning that Terry never responded to the complaint, was done April 17th. When we had another hearing February the 24th, that Terry argued about the answer. The judge knew I had the response to it, because the judge even knew that I demanded a jury trial then. I had to waive my rights to a jury trial, all that stuff. So we knew that Terry responded to it. Something like, okay, well, and I'm reading them like judge just they don't let frivolous motions go through. The judge would have checked it. Okay, well, why is the judge just going to let something frivolous go through like this too as well? Okay, and the judge says she's not going to, attack any more. She's not going to deal with any other motions but this motion right now. Okay, so I'm going to have my moment then to respond to this. Great. So let me just focus on this motion, respond to her strike, and we'll deal with that. Didn't happen. Final judgment came in. Here is, for those who are able to follow me, the tactic to why, because I'm the why person. Well, if it's Terry's fault, then Shelby didn't commit fraud, technically speaking. Fraud to the court, because there is a fraudulent date that changed. So basically, if Shelby submitted something that said motion for default judgment, because motion for default judgment I need because Terry never responded. Okay, now it's for Terry to respond, but Terry's thinking, I'm gonna get a chance to respond later. Terry doesn't get that opportunity. Judge rules, well, he never responded, motion for default judgment, accepted. So technically, and the complaint is not attached to the default judgment. The complaint that has the falsified or the fraudulent rental agreement. That's only in the original complaint, the summons and all that stuff that's connected to the hearing. So a motion for default judgment is, well, it's on him since he didn't respond. No, it's not because of, this fraudulent. He just didn't respond. If he would have responded. So that's my opinion. Why? Let me see more to this. My plans for the plans is to look for housing. I just went to the legal aid today, was able to do that, fill out a report. There have been 2 cases with this that I thought should have been consolidated. It should have been a consolidated case. Back and forth. I hadn't had the opportunity. I hadn't had the vehicle like that to go to apply for the legal aid in person and continue to do other stuff that I thought was frivolous, as far as hearings and stuff that we had to do. And every time we had a hearing that had nothing to do with the actual case, it turned out to be different information, but still something that I guess needed to be done. We'll see. But with that, plan to look for other places. There's a catch-22 with the, I know legal aid, the homeless person department. I spoke with the homeless department and the housing department. Homeless department is saying about the waiting list for shelters. So I didn't even know that we have a waiting list in Broward just for shelters alone. So right now I'm in a motel and yeah, that's it for right now. And it's not free. So, getting back to the programs, she as in the person with the homeless department with legal aid who was assisting me a little bit and asking me, she even asked me about housing and everything. There has been a reason to why I have not signed back into housing is because of this case that I've been pursuing, that I've been trying to pursue back to federal court. If I sign back up with housing, which has happened before, this has happened, where they were going to reissue a voucher or housing, whatever it is, and then there was a paper that came with it that's called a withdrawal with resolution. So a withdrawal with resolution is very, very, even HUD is, their investigative manual talks really, really bad about a withdrawal with resolution, really bad. And they have in parentheses of that, it's I think it's a private, they list it as basically in parentheses a private settlement, which I've assumed the whole time that a private settlement happened, that whole thing. Our Attorney Thomas, if people who followed me, Attorney Thomas Tatum name is involved into this, who personally represented me, that when I spoke to Attorney Thomas Tatum, he denies ever representing me, but somehow it's on a congressional inquiry that Attorney Thomas Tatum actually represented me, this high-priced attorney who happened to be a floor below or above one of the attorneys who allegedly represented the City of Fort Lauderdale the Housing Authority of the City of Fort Lauderdale, or City of Fort Lauderdale, all association with the same group, and something I could not afford, didn't have an attorney. Why is that attorney listed in a congressional inquiry? Just, something's not right. But anyway, getting back to that, I didn't want to sign it, the withdrawal resolution. And if you're not careful with other little subsidiary housing programs underneath the federal division, that is funded underneath federal, regardless of it, it can be reworded the same way where you accidentally sign something, you're withdrawing claims from entity one, because there's I forget what they call it, harmless, something harmless, wholesome, something harmless, or hold something harmless. But there's there's a clause, and I forgot what it is. But either way, but entity one, you hold them harmless of a particular thing, and then it'll say their partners, them and their partners, which may not be listed, who all their partners are, may or may not include, but their partners. Okay, but you hold their partners harmless, and one of their partners happen to be it's a program that's funded up through a federal government. Trust me. 9 times out of 10, it's that. So, pray for me. Again, I was not told about what was it? I wasn't told about it was a final eviction. If I was told it was another reason why I think it's retaliation, racial discrimination, retaliation due to my racial discrimination claim, I wasn't given the due process. So the due process is whoever came the first time, there was somebody who came first, and they put the sticker up, and it was an eviction sticker, okay? And they put the resources that I needed to, I wish I had the flyer. Is it right here? No, it's not. But I don't want to get out of the frame, but there's here's one of them. They give you a flyer that was on top of it. Okay, so that was the flyer. This was the flyer that was added to the first eviction thing. The guy didn't knock. It was so weird. Why didn't he knock and let me know, like, look, you're being evicted, dude? No notice whatsoever. So with that, I know I made attempts to contact the civil department, and then at one point in time I was addressed to go to the website, and I was given those directions about going to the website because I was concerned about an eviction that was coming. And I know I was trying to do something like that, but the eviction came. I thought it was final. Basically with the community support services, this doesn't say, you have 7 days, or it's a preliminary eviction. For me, this is okay, bye-bye. So then the guy who's there, you'll hear him say, the sheriff officer say, I checked the system and I don't see a motion to stay, a writ of possession. I think that's how it's titled, but there's a motion to stay. Basically, a motion to stay is when there's a writ to evict, you can do a motion to stay that. I didn't do a motion to stay because there was already a writ in the system. I didn't know that the way he now comes back, this is the final one. Oh, so you mean to tell me the reason why the guy didn't knock at the door, somebody just didn't want to tell me that this was the in-between pending, because then I would have done the writ. I would have done the writ in less than 2 hours. I would have had the writ done, which would have prevented me from being kicked out. So I just believe it was a failure of due process connected with the racial discrimination thing. Trying to see if there's anything else. I don't think there is, but there was a motion to, now there is a pending motion to set aside the final judgment. Motion to set aside final judgment. I just thought that the judge would have laughed at me, because you can't do, why are you going to do a motion to stay a writ if a writ was already in the system? Versus, I thought the motion to writ should be done before the writ has actually been inserted into the system. The writ was already in the system. But the way the sheriff's office puts it is that, oh, when I checked the system, I didn't see anything, a pending motion to stay of writ. Well, that was the reason why, sorry, not my opinion. That was the reason why the person didn't knock it. They didn't want me to know that it was pending. They didn't want to talk to me. This was the first BSO officer. Didn't want to talk to me or anything else like that. And he was a civil person. Second person came. No, they came with the squad. And I don't know. Nobody wanted me to know. That's my personal opinion. And then when I say nobody wanted me to know, that doesn't include the officers that came out. They're told to do a job. I'm not talking about them. So, don't take any offense to it. It is what it is. I'm not talking about, you have people who are they're taking orders from others. That's it. But I'm not talking about them. I'm talking about people who are pushing or giving the orders. So again, keep me in your prayers. I know this has been a little, I'm barely, sleeping like I need to sleep. I'm in a motel, this is what you saw before. Yes, I'm, doing the washing what I can wash, that I need to wash, and, stuff like that for but anyway, for sanitation purposes. And so keep me in your prayers. Again, I'm overheated. I had to turn the AC off. That's what's going on. In case y'all trying to figure out what, I'm overheated. I'm hot, and I'm ready to turn this AC back on. But I just turned it off because I didn't want to talk loud over the AC and then make any disturbance. I didn't want to do that. So again, I thank you for your time. Pray for me. I'm definitely treading in deep water, legal waters. And the Cash App again is T as in Tom, B as in boy, C as in Charlie, S as in Sam, 360. T as in Tom, B as in boy, C as in Charlie, S as in Sam, 360. And anything would help. That is going to this has not been, for those who follow me, this is not a secret. The Consulting Solutions switched over to, when I thought I was consulting people with their business and stuff, it switched over to community advocate, to me doing this case on my grandmother, to me having it's all about the racial discrimination, Consulting Solutions 360, which is Terry B's Consulting Solutions, the legal approval to do that, to call it the fictitious, which is fictitious name, Terry B's Consulting Solutions 360 LLC, under Consulting Solutions 360 LLC. It's all the same. I just personally, and I'll say this, I've already said before that us as blacks didn't get here by ourselves. I've made that statement, and I'm sure I may have rattled some people. But just the same, I don't like it when, if a black person reads something legally, it's called a loophole or something technical. But in something that I know for my other peers of the opposite color of me may find the same thing, and well, no, they use it accordingly. That's why it's there. So con smart, or con smart. That's how I look at it. Sometimes that's how it can be considered. So I think we all just need to be mindful of that. Stay blessed. Pray for me. I just needed to, while I had the time, to talk about it. because why I don't do the live, I don't do, especially I don't do that live stuff like that in my business. I was concerned for my safety, and I'd rather videotape that. And she was not a part of it. She was not in it because there's an order for her image not to be in there or anything else like that. So I didn't violate the judge's order or anything. It was on me the entire time, the Facebook Live. So stay blessed. Feel free to send me a private message. Thank you for those who have been listening. Pray for me in Jesus' name.